Yes, students, welcome back to iProledge. I'm Theja, your JIGL faculty. As you know that we have started with JIGL series. We have already covered from Article 12 till Article 19. So please watch that video if you haven't watched. In detail, I have covered all of those articles. Let us continue with that session. So in this video, we'll start with Article 20. Yes, all right. What is Article 20? Now, Article 20 gives protection in respect of offense conviction for offences. What is it? Now, Article 20 is applicable on whom? First, we will understand the applicability of Article 20. Article 19, we saw it is applicable only on citizens and not on non-citizens, right? Now, Article 20 is applicable on all persons, whether it is citizen or non-citizen. Okay, this is the first point. Second, it is applicable on criminal matters. It is a protection given under criminal matters. Alright, now how many protections are given under Article 20? There are 3 protections. First of all, Article 20 is applicable on both citizens and non-citizens. That is, it is applicable on all persons. Second, it is applicable on, it gives protection for what offences? Criminal matters. Third thing, how many protections are given under Article 20? There are 3 protections. Alright, yes, let us understand this in detail now. Okay, I will give a situation. In the year 2020, okay, currently in 2026, a law is passed. It says, anyone who consumes energy drink, it is illegal. It says consuming energy drink. Just an example, okay? Consuming energy drink is illegal. Okay, just an example. Yeah. Now, so from the time this law is passed, anyone who consumes energy drink, it is illegal, no? Now, law is already passed. Today, if I consume energy drink, that means I have committed an criminal offense. It is illegal. Now, a person who had consumed energy drink in 2025, in 2024, will we apply this law to the past act and say at that time you had consumed energy drink, at that time it was legal. In 2025, consuming energy drink was absolutely legal. It was not illegal. So now my question to you, will this particular criminal law, will it be applicable on the past acts or not? What do you think is the answer? Understanding the question, right? What is it? Today a law has come up. Will this be applicable on the past act in this example? No. Of course, right? At that time it was a legal act. Just because today you have made an act illegal, we cannot go and punish that person who had committed an act. At that time he didn't even know that it was illegal. That means criminal laws are prospective in nature. What is it? They are prospective in nature. That means from when the law is passed, from that time it is applicable on all the future acts. Law is applicable on future acts. Okay, this is called law is prospective in nature. Okay, now when the law is passed, it is applicable on past acts also. That means law is retrospective in nature. It is retrospective in nature. That means law is applicable on past acts. That means how? How can a law be passed today and it is applicable on past act? Yes, it can happen. If any amendment has come in company law, at that time they say this will be applicable even on the past acts. Your income tax amendment, they say that this will be applicable from the year 2024 only. So from 2024 till this act, whatever from 2024 till this particular law, during that duration, whatever act got committed, law will be applicable even on those acts. This is called retrospective in nature. Most of the criminal laws are prospective in nature, and civil laws are retrospective in nature. Got it? Understood what is retrospective in nature and prospective in nature? Today the law has come, it is applicable from today. Prospective in nature. Today the law has come, it is applicable even on the past acts. That means it is retrospective in nature. Got it? Alright. Now you understood this particular criminal act, it is prospective in nature. Now let's say in the year 2025, in the year 2026, that is today, the law is passed telling that there is some law passed, and for that particular act, punishment is 5 years. Okay, for that act, punishment is 5 years. In 2025, the punishment is 4 years. In 2025, the punishment was 4 years. 2026, the punishment is 5 years. Can we go back and increase the punishment? No. We cannot go back and increase the punishment. Even that is not possible. It says that any new criminal offense, or if there is any increase in the punishment, that is prospective in nature. Any new criminal offense plus increase in punishment is what? It is prospective in nature. These two are prospective in nature. Let's say now, when the law in the year 2026, it was 4 years punishment, and now in the year 2025, it is 2 years. No, the other way around. In the year 2026, it is 2 years. That is the current situation as per the new law. In 2025, it was 4 years. Now you tell me, can we go back and reduce the punishment? Yes, we can go back and reduce the punishment. Decreasing the punishment can be applied retrospectively, but not increase of the punishment. We cannot increase the punishment, but we can decrease the punishment. What have I written? Any new offense plus increase in punishment is prospective in nature. But can we go back and give some benefits? Decreasing the punishment means it is beneficial to the other person, right? We are giving that person some benefits. Can benefits be applied retrospectively? Yes, we can apply benefits retrospectively. All of you clear till here? Okay, great. So let us see what does this article say. Article 21, the first protection. Protection against ex post facto law. Ex post facto law is what? Today a law has come up and it is applicable retrospectively and it is applicable on past events. Law gives protection against ex post facto law. It says a person can be punished only for an act which was an offense at the time it was committed. A law cannot make past innocent act a crime. Punishment cannot be increased retrospectively. Now you understand what does this mean. And it applies only to substantive criminal law and not procedural law. Now, what is an offense? Today, this particular act, is it an offense or not? What is the punishment for this? This is substantive law. Okay, it says whether this act is an offense or not, whether this act is a crime or not. If this act is committed, then what is the punishment? This is substantive law. Article 21 gives protection on, it is applicable on substantive law. But let's say there is some procedural change. First, as per the earlier law, you had to go to this particular court. This is the procedure you had to follow. Now there is change in that procedure. Can we apply that procedural change? Yes. Understanding all of you? that procedural change we can apply. So Article 21 is not applicable on the procedural law. It is not applicable if there is any procedural change. You cannot tell no, we will only apply, we will only consider the past procedure, because at that time when I committed the act, this is a procedure. Now new procedure is not applicable to me. No, we cannot say that. Article 21 is applicable on substantive law. Whether if there is an increase in punishment, then yes, apply Article 21. If at all an act is now an offense or not, yes, you apply Article 20, but not on procedural law. If there is any procedural change, you have to follow that procedural change. Understood Article 21, all of you? Simple. Yes, it says what? It applies only to substantive criminal law and not on procedural law. Understood this sentence? Yes. So if an act was legal in 2020, a law passed in 2023 cannot punish that act as a crime from 2020. Understood all of you? 21. So Article 21 applies only to substantive law and not to any procedural change. Okay, procedural change means understood, right? If at all there is some procedure that is being followed and there is some change in that change Article 21 will not be applicable. Therefore, Article 21 does not protect against retrospective procedural changes. Got it all of you? This is your first protection under Article 21. Protection against ex post facto law. Alright. Next, second protection. Protection against double jeopardy. That means what? A person is punished. Can you punish that person once again for the same act? No, right? A person has already committed a crime and that person has undergone the punishment. Can we punish that person again for the same act which he committed? No, for the new act, yes, you can punish him again. That is separate. But can you punish a person again for the same act? No. That is protection against double jeopardy. Article 22. A person cannot be prosecuted and punished twice for the same offense. Okay, a person is already charged of criminal offenses. What is a person is prosecuted? He is charged of criminal offenses, right? At that time, and that person is already punished. Can you punish that person twice? Can you punish that person again for the same offense? No. Both prosecution and punishment must have happened earlier. If a person was prosecuted but not punished, yes, he was charged of the criminal offenses. He was tried, but he was not punished. At that time, you can give the punishment to him. At that time, Article 20 is not applicable. It is applicable when the person is already prosecuted and already punished. That person cannot be punished again. Okay. So a person is convicted and jailed for theft, cannot be tried again for the same theft. For different theft, yes, that person can be charged. Tried for theft but acquitted, that is, he is released, he is not punished. He can be tried again if law permits. Understood? This is the second protection, protection against double jeopardy. A person cannot be twice for the same offense. Next, protection against self-incrimination. What do you mean by self-incrimination? Self-incrimination means a person is forced to give evidence or make statement that can be used to prove your own guilt. A person is accused of an offense and that person is compelled, forced to tell that yes, I only committed the offense. That person is forced. Voluntarily if he says, then it is different. A person is forced to give some evidence that will be against him, that will act against him. That is protection against self-incrimination. An accused cannot be forced to give evidence against himself. This protection applies only when three conditions are satisfied. What are those? A person is accused of an offenses. First, the protection applies only when the person is officially charged or treated as an accused in criminal case. Okay, that person must be accused of an offense. Okay, and then there has to be some kind of compulsion, not a voluntary act. That person is forced, threatened or pressurized by the authority to speak or act against his will. Okay, The compulsion results in self-incriminating evidence. That means what? The forced statement or act produces information or evidence that can be used to prove that person's guilt. Okay? Simple, a person cannot be forced to tell something that will later act against him only. Okay? So if any voluntary statement is made, that is allowed. Voluntarily that person is confessing that yes, I only committed a crime, that is allowed. But that person cannot be forced. If a person speaks or confesses on his own free will without pressure or threat, it does not violate Article 23. Okay? It applies to accused person and suspects also. If there is any suspect and that suspect is forced, compelled to tell something that would act against him, no, that is not allowed. It does not apply if there is no force or compulsion. Okay. Protection extends to suspects during investigation. During investigation, can the police officer, can the suspect be compelled to tell something that would act against him? No. Article 20 gives these three protection in the criminal matters. Very, very important three protection in criminal matters. 21, 22, 23. Okay, what is 21? Protection against ex post facto law, your procedural law, your prospective law and retrospective law. Understood, right? What do you mean by prospective in nature and retrospective in nature? And then very important thing what you need to remember here is it applies only to substantive criminal law and not to procedural law. If there is any procedural change, then you have to follow that change procedure itself. And then once a person is prosecuted and punished, you cannot punish that person again. Okay? Alright. Next is a person cannot be forced to give evidence against himself. Alright. These are the three most important protections under your Article 20. Yes, next article is Article 21. What is Article 21? It says, no person can be deprived of life or personal liberty except according to a procedure established by law. That means what? See, this article gives two rights. Right to life and right to personal liberty. These are the two things that is given to both citizens and non-citizens. Again, this article is applicable to all persons, whether citizen or non-citizen. Now, these are the two rights, right to life and right to personal liberty. It is given to all citizens and nobody can take this away from anyone. Understanding? What are the two things? Right to life and right to personal liberty. These two things, nobody can take it away from anyone. Except, there is an exception. It can be taken away except according to a procedure established by law. If there is a valid law, there is an established procedure, it is just, fair and reasonable. How is the law? It should be just, fair and reasonable, right? Only this can take away the right to life or right to personal liberty, except according to the procedure established by law. Means, understood what you mean by that? There has to be a valid law, there has to be an established procedure, and how should it be? Can it be unfair? No, it has to be just, fair and reasonable. So these are the two rights, right to life and right to personal liberty. It cannot be taken away from anyone except if there is a procedure established by law. Understood? Now, what do you mean by right to life? Right to life is a very wide term. Right to life does not only mean right to exist. No, mere right to exist is not right to life. Right to life means right to lead a life with human dignity. Okay? Right to live with human dignity. Right to lead a meaningful life. Right to a healthy environment, right to be free from excessive noise pollution. Like that, a lot of things are added up through case laws. Right to life is a very wide term. Okay? Yes, so we will understand it through case laws. First case law is A.K. Gopalan versus State of Madras. In this case law, they interpreted Article 21 in a very narrow term. They said, What do you mean by personal liberty? According to A.K. Gopalan case, personal liberty means physical liberty. Now, physical liberty, when do you say a person's physical liberty is infringed, a person is arrested, a person is detained? At that time, that person's physical liberty is harmed, right? So, as per A.K. Gopalan case, when you say a right to personal liberty is affected, when a person's personal liberty is affected. This is a very narrow interpretation that came up in this case law. Later it got widened through other case laws that we will see. And in this case law, it said that procedure established by law meant any procedure made by law, even if unfair. Whether that procedure is fair or not is not mandatory. Even if the procedure is unfair, that would be applicable. No, that is not what got continued. Later it got changed in other case laws. Understood what was the earliest view? This was the first view of during the case law of A.K. Gopalan. In this case law, two things. One is personal liberty got equated to physical liberty. Second, there was a very narrow interpretation and they told that procedure established by law, it doesn't matter whether the procedure is fair or not. Okay? Alright. In the next case law, Karak Singh versus State of UP, there was expansion of that liberty. The word liberty got expanded. What happened here? In this case law, police conducted night domiciliary visit. The night visit what police would go through. So, court held such visit violate personal liberty. Why? Because it is affecting a person's privacy and right to sleep. So, even right to privacy and right to sleep also got included in the word personal liberty. So, they expanded the definition of the word personal liberty here. Understood? Yes. In the next case law. In this case law, the Supreme Court held that right to travel abroad is a part of personal liberty under Article 21. Now a person's passport is taken away. According to A.K. Gopalan case, personal liberty means physical liberty is restricted, right? A person is arrested or detained. Here, just a person's passport is taken away. Indirectly, that person's personal liberty is affected, right? That is when they held in this case law, right to travel abroad is a part of personal liberty under Article 21. This is well explained in the case law Maneka Gandhi versus Union of India. What happened in this case law? This case changed the meaning of Article 21 completely. Personal liberty includes right to go abroad. The court said personal liberty is very wide. This is a very important case law. You have to remember this case law, Maneka Gandhi versus Union of India. In this case law, the court said personal liberty is very wide and it includes traveling outside India, not just freedom from arrest. As per A.K. Gopalan case, a person's physical liberty is affected. Just that only means personal liberty is affected? No. A person's passport is taken away. That means his freedom to move is infringed, right? It's affected. So procedure established by law must be fair, just and reasonable. This was said in this particular case law. It is not enough that just the law exists. No, how the law exists is very important. The procedure in that law must not be unfair, arbitrary or harsh. Article 14, 19, 21 are interconnected. These articles do not work separately. If a law affects personal liberty, it must satisfy all three articles together. So Article 14 says what? The law must not be arbitrary, right? It has to be equal and fair. Equality. Article 19 is what? Restrictions. And that restrictions you are imposing has to be how? Can it be, are those rights absolute? No, it comes with restrictions and that has to be reasonable. And then Article 21, procedure, how should it be? Fair, just and reasonable. Got it? So these three articles are interconnected. And then effect on earlier view, A.K. Gopalan case, the old narrow view that accepted any procedure made by the law was rejected. How should the procedure be? You have to remember, just, fair, reasonable. Alright? Yes, only such procedure will be accepted. Now, right to privacy. Privacy could be restricted for public interest, security or law enforcement. Certain restrictions are valid. So, what do you mean by procedure established by law? Procedure established by law means that person's life or personal liberty can be taken away only by a valid law and only by following the procedure laid down in that law. what procedure they have given, the same procedure has to be followed. Okay. Two things you have to remember here. A person's right to life and right to personal liberty cannot be taken away unless and until there is a procedure established by law. That means there is a valid law, and in that valid law, what procedure is given, how should it be taken away, the same procedure has to be followed. Okay. So this is your right to life. And Article 21, in today's view, it also includes right to bail. Not just right to sleep, not just right to privacy, it also includes right to bail, right against handcuffing, right to speedy trial, only right against handcuffing in all these petty cases, and all of that handcuffing should not be done. Right to speedy trial, right to free legal aid, these are all included in Article 21. Clear? Next. In this case law, Swapnil Tripathi versus Supreme Court, the question was about live streaming of court proceedings. Whatever is happening in the court, should it be streamed lively for the general public? What was the issue here? Petitioners asked that important court cases should be live streamed to public so that even they can watch. We should know, right, what is happening inside the court, because whatever justice is imparted, whether it is imparted properly or not, all of that we have to be aware of it. So Supreme Court in this case held that live streaming of court proceedings is important. It is an extension to of the principle of open justice. Justice should not only be done but must be seen to be done. Very, very important. Justice should not only be done, it must be seen to be done. Okay, why is live streaming important? It helps public understand court proceedings, improves access to justice, makes the judiciary transparent and accountable, strengthens the public confidence in the court. So live streaming in the present situation, is it valid? Yes, it is. Okay, it supports open courts, access to justice and judicial accountability. Got it? Next. Article 226, writ under Article 226. When a person's fundamental right is violated, that person can go file the writ application under Article 226 in High Court. In which court? In High Court. When a person's fundamental right only, okay, when a person's fundamental right is violated, that person can go and file the writ application in High Court. So High courts normally will not entertain a writ application, writ petition, alright. So it is an effective alternate remedy. If an effective alternate remedy, appeal, revision, tribunal, etc. is available, then we have to first use that. See, writ petition can be filed in High Court under Article 226. Okay, in our next video, we will cover in detail Article 226 and Article 32, a very, very important article, your writ 226 and 32. We will also see what is the difference between the both. So as of now, just understand that a writ petition can be filed in High Court, and what does the law say? If at all there is some remedy that is already there, law says that you have to file an appeal. So first follow that and then exercise this Article 226 and file the writ application, writ petition. Okay, so if there is an effective alternate remedy such as appeal, revision, or if through tribunal is available, then you have to use that first. Okay, if a statute provides an appeal mechanism, the person should first use that, not directly approach High Court. Okay, important exception, that is when High Court can still entertain writ. Okay, despite of other alternate remedies, when High Court can directly intervene and entertain writ. Even if an alternate remedy exists, writ can be entertained if authority did not follow the law properly, authority went against its jurisdiction, or authority had to consider some important legal matter and it did not consider. At that time, High Court can intervene. Violation of judicial procedure, there is a procedure that has to be followed and that only got violated. So basic procedural fairness only got ignored. Next, action is based on repeal law. Authority is still following an old law. Okay, so authority relied on a law that no longer exists. High Court will intervene and tell this is an old law. Violation of natural justice. Opportunity of being heard. We have to hear the other party. No hearing bias. Arbitrary decision is being given. At that time, High Court can entertain writ. Understood, all of you? This is Article 21. It says the final clarification by Supreme Court. It is an effective alternate remedy. If an effective alternate remedy exists, then High Court should normally refuse the writ, but the above exceptions override this rule. Alright, understood? Yes, students. So the remaining we will take it up in our next class. Thank you. Please do like, share, subscribe to iProledge for more such videos. Yes.